The truth is, they're as dumb as they come.
Huh?
There's mosquitoes the size of bald eagles in that dadgum swamp.
Going on, Freakazoids? All right. How the hell's it going out there? Really? That good, huh? Sweet. Awesome. All right. Well, we have day 3 of the preliminary hearing. By the way, grand juries are really rare in Utah. They hardly ever use them. They like to have the public be able to see. All right, so that's the deal. That's why there's no grand jury. Grand jury kind of made sense here, but I think it is important in this case for the public to see every single detail, because there's lunatics like Candace Owens and her wacky followers who believe something. And listen, I actually, I feel bad for the people who have only been watching those kinds, the Colemans of the world, the Candace Owens of the world, just extreme lunatics, and they're using you, okay? They are an embarrassment to mankind, especially the true crime community, which they aren't a part of. They're just lunatics that are, I don't even know how to explain it to you guys. If you knew what, this case is, in my mind, completely put together by the facts of the case. I have it all worked out. And I even come up with other things daily, like, oh yeah, this is what happened. It's crazy, but it all makes sense. There's nothing in this case that I go, something just doesn't add up. And I look for the facts. Like last night on the show, I saw that in the video that the prosecution put out, they had it was flipped. Okay, 2 of the, right when Tyler Robinson walks up the stairs, underneath the garage, when he comes up the next flight of stairs, they had that video flipped horizontally, and I think but the text on the screen was correct, oriented. So what it means is that the camera itself has flipped horizontal video, and when you flip it correctly, it makes complete sense. So it was kind of bothering me, like, what's going on? So I sent that information off. I don't know if anybody got it or they care, or how that works. You'd have to edit it, flip it back on their end, but then the numbers are backwards. So, I don't know what you say, but it's not, there's nothing to gain by it. Okay. There's nothing to gain by it. All right. Now on the screen right here, I just want you to see, this is something else that I found a long time ago. Okay. So, Bartholomew, the guy that shot this video right here. Hold on, let me turn this off. My alarm is gonna. That's the backup one. He had this video out there, Bartholomew, and on his video it says right here it starts at 12:04, but 12:04 is really, you don't have the seconds involved, right? So I told him, hey, I need the exact time of the gunshot here, So then he sent me back another one that has adjusted. Original is 10:04, and I guess it says 10:04. Well, the original is 10:04 and 20 seconds, and then right up here it was just 12:04. So here it's 12:04 and 20 seconds. So now I had a seconds to work with. So after applying that, putting a timestamp on the video itself, it turns out the gunshot is right here. It's just right now it's happening. But then, these guys flinch because of the sound wave, right? So it's 12:23:28 is when the shot happens, right in between 12:23:28 and 29. So that's when it happens, right? That's what I determined months ago. Like literally, I'd say maybe 8 months ago. All right. Then yesterday, we had in the press conference, or not the press conference, in the hearing, he actually says that it took place at 12:23:28 seconds. So isn't that cool though, you guys? So if you're on this channel, You get the factual information. And even when I put that out, people always have to, like, try to sleuth that. I don't know, Gray, you're not accounting for the, it's garbage. I actually know what I'm doing. It's weird. I know it's strange when you actually have somebody that knows what they're doing. But anyways, how about we listen to the portion yesterday when he went over the surveillance footage. I think it would be interesting. All right, here we go. Oh, wait, before I forget, though, I want to bring this up. So in this video that we're about to watch, somebody put in the comment sections that he must have put his backpack in the woods on his dry run. And I think that's what they're referring to. And it's just, it's crazy. So think about it like this. So he does the dry run. Well, let's listen to it first and then just determine which pass they're talking about. I think the person may have gone up and back around and then was testing how to get, Tyler Robinson was testing how to get to the wooded area from up here. So that's why he left his backpack there, and he's sort of pretending this is what he would be doing. Man, I think it's crazy, man. I think that's exactly what he's doing. Hey, thank you so much there to Laura Rhea. Is it Rhea? Said, thank you for breaking everything down the way you do and making it easier for me to follow. Amidst all the crazy conspiracy stuff online. Plus, you crack me up. All right, cool. I do try to make people laugh from time to time. All right. True crime can get kind of dark, Well, that's what the topic is. It's not the happiest place in the world, but when you're not talking about the crime itself, I try to use some humor, Or sometimes it is the crime, how stupid somebody is, All right, so let's go back to this right here. Oh yeah, I have it muted. So let's just play this again.
Just want to make sure it's on your screen, Agent. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle
I'm wondering
belongs
if
to
that's
Mr. Robinson?
flipped too, that one.
Information
Their vehicle belongs to Mr. Robinson.
information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage.
Well, I don't think it is, but I'm
It's
just
the
saying there's
individual in
something that
the-
doesn't make sense about
The
the
red
car.
T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
And his
Where
parents
does he
do,
go
too.
from there?
He heads out of the parking garage on foot.
Okay, so this is where they have it flipped. They accidentally, whoever installed the camera has it flipped. What?
Into the campus,
Not this one, not this one. The later videos, not this one.
and actually goes to the quad area of the campus. At that time, he makes contact.
Although, I don't know. Hold on a second. That's weird. Is this the same? Let's see, if I flip it around. Let me just try doing that really quick. Well, God, I always have so many thoughts I want to do. I'm trying to remember if that's the same. Let me go look. So this is called the parking level 2 stairs northeast. Okay.
Contact with some representatives from TPUSA.
By quad area.
Sorry, the amphitheater is what I've previously referred it to.
All right. So he goes up onto campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
This is his first trip onto campus that morning. He was there for about an hour. What do you mean, is this live? No, it's from 8 days ago. What do you mean, is it live?
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
Oh wait, hold on a second. Let me go to this other screen over here. Yeah, I think that's better. I don't know if you could see. You can see the top of the screen now. Hold on, let me go back a little bit. So there he is pulling out up there. See that? He just parked right there. Hey, Dragon, let me go over the case so I want to go over it. I'm not going to listen to you, okay? I'm not talking about the car in the parking lot. I'm talking about the stairs, all right?
And
Go
where
do
is this
something
parking
else.
structure located on campus?
My God.
It's just off of Campus Drive. It's a short walk from the amphitheater.
I'm trying to make sense of the internal
What do we see?
garage myself. It's pretty weird.
That's
how-
the vehicle exiting with Mr. Robinson driving the
There he
vehicle.
goes. Well, then quit blabbing in there over and over and over again, D. It's you that's causing the problem, nobody else, right? So here he comes. He's leaving right there.
Now what do we see?
Yeah, passive
This
aggressive.
is Mr. Robinson
Jeez,
returning
man.
to the campus on foot from
All right. So here he
the
comes.
neighborhood to
He's
the
got the
northeast.
backpack on. You guys see
You
that?
can see he's wearing the same clothing as in the previous video,
The dry run.
and he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored T-shirt.
He's got the backpack there. See that? It looks like there's almost nothing in it. It's almost like he's just going to try to use it as just an element later. I mean, I think let's just listen. Listen.
With gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Yeah, well, I don't know if it's just for blending in on this particular trip.
Just
Yeah, it always looks like you're doing something. You know, ask yourself this: if you somebody, oh my God, we're still talking about it. If you have somebody on, let's say there's somebody sitting on a park bench, and they're, well, here I'll show you. Let's just say that you have somebody sitting on a park bench and they're just going like this. They look like a nut job, right? But if they're smoking a cigarette, you know, they're just somebody sitting around thinking about today, right? So if you don't have a cigarette and you have nothing in your hand and you're sitting on a park bench, you are a crazy lunatic when everybody's watching you, all right? So somebody like this, if he didn't have a backpack on, walking around on campus, you might go, what the hell's this guy doing? You know, because he had nothing in his hand at all, right? He just has a hat and his shirt, and he's just walking. You see? So that would stick out. Oh, he's got a backpack, you know. So it might serve two purposes, but I think on this one, he was going to see, how can I go get that gun? I mean, not the gun. Go get the backpack after he put it in the area where he puts the gun later. All right, so hold on a second.
after 10 a.m.
And does he leave the parking structure eventually?
I don't think
He does,
does.
yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry,
Where did he purchase
No,
the food from?
no problem.
Chick-fil-A
there,
in the
Dragon.
Sorensen
I'm
Center.
just saying, man. I don't,
And where is that
just working
in
through
relation
stuff.
to the amphitheater or the courtyard?
it's kind of on the northeast side of the amphitheater. It would be
Okay.
on the upper back edge of the
Let me
amphitheater.
rewind this a little bit. What's he saying?
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen
Yeah, so
Center.
he went to the...
And where is that?
I didn't even pick that up the first time, but he went in the Chick-fil-A, and that's in... I know where that is because I walked through there. I think I actually have a 360-degree video inside of the food court. All right, and that's right here. That's this thing. Oh, there it even says Chick-fil-A right there. But it's in this building. I think it's right in there. I'm not sure why it's right there on that, but I think it's inside of that. So it's right next to, where the shooting would take place. It's crazy.
Relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive, into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
Okay, let's see. Where's the Gunther building? There it is. Wow. He went all the way over here. That's crazy. Wow, it makes you kind of wonder, was that how he... Man, I don't know. It's bizarre. And then what was he gonna, what did he say right after that? The Gunther
Science building. Then returns back onto campus.
Okay, I gotta go back again.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive, into a wooded area.
Ah, there you go. See, that's amazing, right? So after he goes, let's do that again. Let's just rewind it a little bit more.
The amphitheater or the courtyard?
It's kind of on the
Just a second.
Just the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the
Thank you. Born to raise
amphitheater
hogs.
or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive, into a wooded area.
So they actually have him. So the camera, man, that's crazy. So he's over here at Chick-fil-A. Then from there, he walks probably just, up through here, up and around, and then across Campus Drive. So the camera that they have that's right here, see that little point that sticks out right there on that building? That's the camera, right? So that's what you saw yesterday, or it's in that video, where he's walking across and he disappears down there. So that camera there films him walking back over there into the wooded area at that time. But then after that, he goes over to the Gunther. Man, that's weird. So let's take a look at that then. It's always interesting, like I always say, location is evidence.
On what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally.
See, he's no longer carrying the backpack, you guys. So somebody in the comment section mentioned that he left I didn't pick that up yesterday, that the backpack was left in the wooded area, you guys, when he came back onto campus. So I think he left it in the wooded area to see how he can get it from up above on that street, above it. Isn't that crazy?
Wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Hopefully you guys are paying attention to what I just said. It's pretty interesting.
Where?
Then goes across to the railing that gives access to the roof of the Losi.
Oh, interesting. So he did, wow. So he was in this building over here, the Gunther building, and then he walked probably across over here and then came out right there and then went to the railing. That's what it sounds like. Let me hear that again.
He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
Wow. That's okay. So he did some crazy different route. Is this the computer build? What building is this right here? Let's see. Computer science building. That's it. Oh my God, yeah. So that's exactly what he did. He went in after going to the wooded area. So what he probably did was go around over here somehow, get into this building, and then cross this little walkway here, and then from there he gets out into that area. This is on his the dry run. This is the dry run that he's on. So he's checking everything out. So it's not totally a dry run, I guess. Or is this still the first one? I guess, man, it's so hard to put them all together. But he walks across here, and then he checks it out. So I think this is the dry run. So he goes over there, he checks it out, and he checks out his wooded area again. Yeah, it's interesting, too, because if we go back a little bit, let me just go back. See, this is the part where they have an error in it. See, when you go up like this, watch.
Just after 10 a.m.
And does he leave the
See,
parking
that's after going through the tunnel and then up the stairs.
structure eventually?
Now watch.
He does, yes.
Okay. And during the
This is wrong right here. See this thing that says parking level 1 stairs northeast? Isn't that the same one that we saw earlier? That's also, see, this is flipped right here. This video here, it doesn't make any sense. And it didn't make any sense when I was watching it because I know what it looks like there. And this is a camera filming down at him. And so this is flipped horizontally, okay? So I fixed it in another area here. I know I'm kind of all over the place, but it's just, there's so much to do. It's crazy. So this video is flipped right here. And I fixed it in another place, but he should be coming up from the right over here. And then he turns left to go out onto the street. And instead, he turns
goes
right.
after he leaves
And that doesn't exist. So that's when I knew that was a problem.
the parking structure.
And look at the wording and the time stamp and everything is normal. So that means the camera itself is flipped horizontally.
Yes, we were able to track his movements on campus. He went to Chick-fil-A.
Okay, so we already did all that part.
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive.
And then he comes out without his backpack on.
The Gunther building and the computer science building. And
goes
then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
That's funny because that's the exact time I predicted because I'm the one that came up with the dry run starting at 10:08 where we see him on that camera. Candace Owen said it was 8:08 in the morning. Absolutely wrong. She lied to all of you guys, all right? So it was 10:08 in the morning, walking by, and then 10:07, 10:08. And then it was verified because we see it right here at 10:09 on the other clip earlier coming down the stairs. And then I thought, well, he probably left there about 11 because at 11:45 he's already changed clothes and he's walking down the street way out on, I think on 800 West, or I think that's what it was. Maybe it's north or...
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
Man, this is crazy. He put that backpack in the wooded area. He didn't have it on. He says that later. I don't really watch her
Were you
either. I
able
just
to,
watch the
refresh
clips
your
of
memory
her
as far as the
saying
time?
stuff.
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
It was just prior, like
And
11:50.
before we go any further,
Why not
the
say the
parking
time?
structure that he left initially, Where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
Why do they need to know that?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment.
Yeah, he mentions in there that he doesn't have his backpack on when they see him on video at some point on that second trip. So what that means is that he left it in the wooded area. And so he left campus somehow. They didn't tell us exactly how, but I bet you he went up here and he tried to figure, because he knew that he could access it. So he was going to practice how to get down to where the backpack was. And then he grabbed it and then went back up and then went to the car getting ready for his final run. Now he knew that he had the ability to go get the backpack or whatever he was going to leave in the woods, meaning his rifle and blanket. Isn't that awesome? I think that's pretty cool. I mean, I think that's just, it's cool to have it all. It makes sense now, everything. So on that trip, he intentionally left that empty backpack in there. And then he obviously got it again. So he must have went up around in that neighborhood and then figured out how. So I wouldn't be surprised if somehow this house has him walking at 11:05 or something. And then the guy that I got my footage from over here, maybe I should get a hold of him again and see if he walks by that area, going up to the car. Now, if you were watching yesterday, we have some pretty amazing information here with I think it's on this one, in this clip. Yeah, by the way, here's it fixed.
Turn to
on
campus.
See, listen.
Just after 10 a.m.
See, watch,
And
I fixed
does he
the
leave
camera.
the parking structure eventually?
He does, yes.
Okay. And during this visit,
See that? That's what it's supposed to look like. See how he comes out from the right? Now notice all the text is backwards. That's what it's supposed to look like.
do you know where he goes?
Then he goes out
after
on
he
the
leaves
campus,
the
right
parking
there.
structure?
Yes, we're
Hey. Looked like he's 6'3", I knew. Yeah, I can prove he's about my height. Right around my height, because I have video of myself in the same spot in there. What was I just about to go look at? And I always get so distracted with, what was it? Oh, yeah. So this right here, if you missed it, there's this aerial photography plane that was flying over. It did this sort of grid thing, and then another place. That's what they pay. They get paid by people to do this. And Candace Owens will turn it into, see, they knew he would. It's just ridiculous, okay? But in this video, there it was right there. Watch this. Right there. That vehicle right there is, this footage, just so you know out there, this exists. Watch this. He's going to click on it, and you'll get to see the time on it. Now, that was the earlier one. So there's two different shots of the vehicle parked there. One is this one right here is 11:18. It's also there at 11:26. And this is a Dodge Challenger. Go look at it. We went over it last night again. It has that exact little shape on the hood there. It's a Dodge Challenger that was parked right there. Now let me show you where that is on a map. That's right here. It's incredible. So when he came in, he came like this. When he left, he probably went like that, ran up, got into the vehicle, and headed north and went over to the mall over here. It's all planned out. This is like incredible. And I guarantee you that's I'll say with a 95% shot that is his Dodge Challenger parked right there. It was not parked there at 11:10, but it was there at 11:16. So isn't it interesting that he's leaving campus at right around 11, probably gets to his car and then moves it to here, getting ready for his final run. All right, so how about that, you guys? How about that? Well, thank you. Looks like none of you even noticed what I just showed you on the screen. I mean, it's just like you guys are you're too much, man. How about you type stuff in? See, the thing is on my channel, I guess it's because I'm so interesting. You're all just listening carefully. But on other channels, people are typing and just bullshitting around, and that's why they get so many views, because their YouTube looks like, wow, look how engaged those people are. You know, we need you guys to be communicating in the chat. And I bet you right now, if everybody started saying, hey, typing in stuff, all of a sudden we'd have 200 and something people in here. I never get the big crowds, even though I have the best coverage by a mile. It isn't even close. You can pretend that somebody else is doing something, but it's just not the truth. All right, let me go over here. I gotta get this fixed. Oops. All right, I think it's gonna be starting somewhat soon here. I don't know. I gotta make it smaller like this. There we go. Yeah, so this is a pool camera, by the way. Like it's everybody has the same thing. So it's on the screen right there. Well, how can you not understand it? I just explained it really carefully. He left it there. Oh man. Is that really? That's not really what it's going to sound like, is it? It's like dead as. Can you guys even hear that at all? Is there a? Let me go check and see if it's like that everywhere. That's wild. I hope somebody points it out to him in there.
From California.
Yeah, so that's this video is like that. Hold on.
Of privileged or private discussions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off, so please come to the lectrum when you're addressing the court. Second, the court will address the camera and still photographer, camera operator and still photographer. And if you both could come forward, please, to the lectrum.
All right, is that good now? All right. I knew it was playing. Man, that's crazy. They better fix that over there.
All right, could you both state your names?
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good afternoon. Could you state your roles for today's hearing?
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court's standing decorum order?
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
This is.
No.
Do you anticipate
I
any
think.
difficulties complying with the order?
No.
Thank you both for your cooperation.
I think it's the right one. Why are you asking that?
As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone in the courtroom
Hey, where's everybody
may be
from?
addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all
Arizona.
spectators shall remain quiet,
Colorado.
civil, and orderly at all
Michigan.
times. Spectators
Alabama.
shall not engage in conduct
Wow,
that
we got
is
the whole country in
distracting,
here. All right.
disruptive, provocative,
Richmond.
disrespectful, uncivil, or threatening in any manner.
Panama.
Spectators shall not
City,
make
Florida.
audible comments of any kind, shall not shake or nod their heads, and shall not make
Erie- I've been to
gestures
Erie,
or other
Pennsylvania.
visible reactions during their hearing. Spectators shall also not wear or display pins,
Okay.
buttons, signs, clothing, photographs, or other items expressing support for
Illinois,
or in
Missouri,
opposition
New
to
York
any
City.
person connected with this case or expressing any position
Hello,
concerning
Phyllis,
the status of this
Missouri.
case
All right.
as a capital offense.
God, there's
Court
cool people in
appreciates the
Missouri.
cooperation of
Wow.
all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state,
G'day,
if you wouldn't
mate.
mind coming forward, Mr. Grunander.
G'day, mate.
Thank you, Your Honor. We anticipate
Hey,
presenting
thank
evidence
you.
through Agent Brian Davis
Thank you.
this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
All right, there you go.
Good afternoon, Your Honor.
Good afternoon.
Michael
Mr.
Berg for Mr. Robinson.
Oh,
Judge,
God.
we have two remaining witnesses, Ms. Oliver from the ATF and Ms. Carner, also from the ATF.
Okay, this is going to be about the bullet fragmentation.
All right, and to both parties, thank you, I
Thank you.
appreciate that. Do both parties anticipate any issues?
What did they say,
concluding their
Cindy? I
case?
missed what he said.
Obviously,
'cause
there's
I was
variables,
clicking on stuff.
cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge.
This can go the whole
Just want to highlight
week.
one issue for the court, because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102.
Twigs.
We have provided the state, I want to say about a day and a half ago.
Hey, thanks,
with
Tracy
proposed
Von Braun.
redactions, because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state, so the state could
had bad dreams about this
raise
guy.
any concerns about the accuracy of the
Last
transcript.
night.
That's not an issue. The admissibility of portions of the video or
Woke
the
up in a
issue is
cold
about
sweat.
20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Gernander, do you wish to be heard?
Yes, Judge. Your Honor, the state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right. Well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right. Does either party require the benefit of the record before we begin? To the state.
Here we go. Here we go. Is this Twigs?
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles really at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102B3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool, and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that's conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry, I have
The
two
judge is like,
microphones.
oh,
I'm just
you're
trying
again? Oh, God.
to,
I see you have a...
technologically savvy.
That was so good right there.
The 104
That was so
issue, I
good.
agree completely with Mr. McBride on what he's
The
saying.
judge is like, oh, I see you have your computer with you. Oh, geez.
Because
Oh, God. Here
of
we
the
go.
Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary
And
hearing.
then he realized
which
he
of
looked.
course
He
is a
know he
fact.
looked like that.
Specific inquiry by this court.
That was so good.
We will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly.
Turn it more towards the camera.
Because if it's published, I want it to be meaningfully able to be viewed. And I noticed
good job.
somebody sent me a screenshot.
It's 45-degree
that
angle.
creates an interesting angle that kind of distorts it. So in the interest
Right, I've had to
of-
fix it on my
if we're going to be
videos.
transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate
I've had
that.
to widen it
All right.
50%
Anything further?
to get the right look on it.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there is a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
I just need some other tables besides the 3 so we can try.
All right, if you all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on, and And if I could borrow somebody to do that.
This
to
is
the
where you need
witness
one of those
monitor as well, so we all get them in sync.
dorks that
Thank
are
you,
really
sir.
good at figuring this shit out.
I appreciate that. And for the lectrum as well, let's just see if we can get that up, because that could
Hey, thanks,
cause a
Phyllis.
delay. I just want to knock this out first. Yes. Where would that TV go? If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV.
Yeah, like what they're talking about is
transparency needs to be viewable.
I've had to take the
Very
video
concept.
and stretch it out.
All right, yeah.
And
let's
then it
go ahead
also
and do that.
distorts the
How
top
are
and
the
the bottom
monitors looking?
because it's farther away
Nothing?
from you. So you have to move the far right portion up, the far right down, and then widen it. Then you get the right look.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop?
Like
to
that's
allow
what
us to
I did in this
project?
one here.
That may be the issue.
Mr. Ellis is plugged in.
All right.
This was way narrower
Let's take a
than
look
that.
here. I appreciate the party's patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
And the television?
All right, and on the screen monitor here, it looks like something came up.
I'm glad that he's
All right.
really
and-
focused in on this,
all right,
okay?
we'll just hope that the monitor for the witness works as well. All right, so we're ready to go? Just bring it in and go ahead and we'll get started. And how much time is needed for that?
Nona me cakes? Thank you.
Well, let's go ahead and proceed, and then when we
thanks for the
take a
green.
break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but
Wow,
the
she
truth,
sounds
so
sped
help
up.
you God.
All right.
The
Agent,
court
if you
calls
can
Agent
sit to your left,
Davis.
Water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
It's Peace Officer Standards and Training.
Did you complete that?
I did,
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a alcohol enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a FARO certified. It's a 3D FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm I've been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI?
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large-scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've So as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz.
I
it was
flew right
Agent
next
Folger
to
with
the
FBI,
Egyptian
Agent
plane.
Anderson with FBI, Ryan McBride and myself, and the two pilots
And who is Ryan McBride?
with the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground
In southern
to the
Utah.
Washington County Sheriff's
It's in
Department.
southern Utah, where Tyler Robinson lives there. That's where he lives.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's
There's the
Department. We
border
also
right
have
there.
agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before
His car
midnight
was in the
of the
driveway.
11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors.
That
There
might
were
be his
some
car.
federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. or I guess, how did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was
go.
interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed
She
Tyler's
sounds
father?
just like that
I think I might have
CNN.
misspoke. It was Agent Holgreen, Agent
Correspondent.
Cox that met with his father.
And then who
Identical.
spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Hit the like button, everybody, please. Thank you
Down
very much.
in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, then he was formally arrested at that time.
And I'm going to come back to that in a second.
Yeah, Caitlin Collins, exactly.
Well,
she
excuse
sounds
me,
exactly like her, doesn't she?
Where did the arrest take place?
At the Washington County Sheriff's Office.
Even sort of looks sort of dark hair, you know.
And what date did that happen on?
Would have been September 12th.
That's a host,
It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
You're just going to do the redacted version. And that may happen a couple more times as we go through exhibits
I
because
understand.
of agreements and disagreements that we have.
Thank you for the heads up.
And plus, I just want to
At
interrupt
Washington
over and over and
County
over and
Sheriff's
over.
Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Yeah, it's just literally exactly
Is that
the
standard
same.
practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview room in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer
image with audio, and we've agreed to a shorter image without audio. And so
Wait, what happened?
That's correct, yeah.
So we're fine with all three steps as to this exhibit.
All right, does the state wish to
Hold on a
review?
second.
As to this exhibit.
All right, does the,
So proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
What happened there? That's weird.
That's correct, yeah.
So we're fine with all three steps as to this exhibit.
all right, does the state wish to review?
I'm speeding
this
up
to make sure that what's
25%.
queued up
Get
comports
caught
with
up.
what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
What do you mean you need the audio? What are you talking about? I can hear it perfectly. What's going on? Yeah, it looked like she may have said something, but we couldn't hear it. God, this defense team has just been a joke here. Just
It's has no audio, so we would like to admit and publish it at this time.
there's
Right,
no
State's
audio.
Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections.
They didn't
which
turn
have
the
been
damn TV
previously
again.
Reserved in
God,
writing
you
and
idiots.
reiterated
the
over the last
freaking
couple of
TV.
days. I assume that we don't need to start over with that today.
thank you. I appreciate
It's
that.
still
I
at an
note the
angle.
standing objection by defense as previously made.
See how the top and this
That
part
objection
are
is
narrower
overruled,
than
and this
over
exhibit
here?
is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15.
Yeah, I saw him
may
pointing
be-
hard. I saw him do that. I don't know what he was trying to say. But look at, they did not fix the television.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
Wait a minute,
And
that's Tyler
although you're
Robinson?
Watching it on video, what is he wearing at this time?
Holy shit, he's got the
Rocking
same
a
damn
dark colored
clothes
baseball
on.
cap with has like a, I believe it's like maybe the Harley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Where is it?
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any,
He looks
I guess, personal
exactly the
property
same
taken
as
from
he
him,
did
clothing,
at the gas
anything like
station.
that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail.
It's going to be frozen for a second.
Which gives the individual's personal identification, the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI.
That's what it's
along with
supposed
the
to
Utah
look
State
like.
Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
His furry buddy.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate.
They can't show him sit down and show his face?
With the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George Court office, courthouse there. They met and discussed briefly. I was going to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. It sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
I bet you Tyler Robinson didn't smell very good that day.
And how do you know that?
Just being honest.
I reviewed it.
Hey, thanks, Roll.
I reviewed it in its original. As soon as it
South
came to
Carolina.
us, I've seen it prior. So
And Kimberly, if I can have you slowly scroll down.
Thank you, Rolo, SC. But man, he had that same maroon shirt on for like 2 days. That's exactly what he's wearing, by the way, at the gas station. There, while they're talking, I'll go over and get it. I think it's over here. This one? That's not in that one.
Sorry, Judge, if I can just have a moment.
You may.
See, look, he's wearing that clothing right there. And then right there at the gas station. See him? Right there. That's him at the gas station heading home on the 11th in the morning. I mean, look at that. I mean, it's so obvious, right? I mean, it's ridiculous. And then here he is right here. Look. Look. That's the same damn, look at the maroon shirt, jeans, the hat. There he is at the police station. You see that? Right there. I know it's kind of small on your screen, but I widened it out the way it's supposed to be.
I apologize, Your Honor. I misspoke. It's not 14.1. It's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, State's Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
If I may approach.
You may. Thank you.
There's his Dodge Challenger right there. I mean, my God, you guys. I mean, this, like I've told people before, this is the strongest case I've ever seen in the history of true crime of the cases that I've covered. I mean, it's like unbelievable. It's ridiculous. You know? And he's the same guy walking by right here. He just doesn't have the jeans on. Look, he's got the same damn shirt on. Unless he's got like 9 different maroon shirts. Okay, there he is. Right there. And now we have other footage of him on the new stuff right here. Look, he's got the maroon shirt on in the morning. Right there, walking up the stairs. Same hat and everything. And then later he's walking here. Doesn't have the maroon shirt on now, but I think it's on underneath that shirt. He just immediately takes off the shirt, his pants, or maybe he might have just taken his shirt off. He may have still had jeans on. I still think when he's running by later, he's got.
All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is.
It's right here.
It's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the
Wait, let's say
auditorium
southeast.
section that we've been talking about where
they're saying it's
Mr.
over
Kirk was
here.
stationed?
It's east of there.
This one.
East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Yeah, so it's right there.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a
Oh,
live
that's
round?
interesting.
It's a round that had not been fired.
23, that's
so
from
still had the projectile, and it was a fully
AR-15.
functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up and fired. It still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
Sounds like it's on this building over here.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
Perfect name, by the way.
Who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall it happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution, from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not, I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line, And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence States Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio.
Okay, I'd be okay with
the
audio.
video within the courtroom
I'd be
itself
okay with the audio.
to be captured.
Yeah, I don't need to
is the
see
state's
it.
position.
It'd be cool if they did a still frame of them. And
Your
then
request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom, and the audio is able to be transmitted.
I'm okay with
Just
that.
not the video via the camera. Is that my understanding?
Correct. That's the state's position.
All
Sounds
right.
good to me.
And
I'll take the audio. I don't need to see
in
his
regards
face
to
while
this
he's talking.
exhibit,
The audio is what matters.
is in the, as State's Exhibit 16.
I mean, I'd like
is
to
there
see
any
him.
portion of that recorded
We should do a
statement that
still frame of
occurred
him and then play
before
the audio.
That'd
be fun.
The 11:02 warning was given to Mr. Twiggs.
Not that we are presenting today.
Okay. All right, turning to the defense. Mr.
Oh,
Novak.
God. Here we go. Objection, objection. A 17-hour dissertation.
So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions.
Oh, God. This is just...
Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript. Excuse me. It's only a 20-page transcript. We have given the state a transcript we prepared.
Whenever this guy comes up, we lose a lot of viewers. I mean, it's like
Ahead of time,
30 people
so that
left when I
state
saw that guy's face.
Could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of
And that was a
the
sound
moment
effect,
that the
not
state
me
doesn't
actually
have any
making
dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 11:02 interview. There's no surprise here.
Okay, great. So let's just hear it then.
There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a
Score
problem
and 7 years ago today.
if Ms. Hunt had just said to Your Honor,
He thinks he's so interesting.
following
you know?
Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because
makes our client look bad.
Categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion
Oh my God, I'm going to talk about
that
it a
the
little bit.
entirety of an
Holy
exhibit, which
shit,
may
man,
not
it's
be
hours.
admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is.
Mr. Prigg.
There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court.
Look at the judge's face
by
and
the
then
state.
listen.
There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So
The truth is, you're as dumb as they come.
I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today, we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that.
That was
without
very
having to
kind
compare
of you.
to-
You know what? We're going to rule for you.
The other thing I want to say
Oh, so nice,
is
you know.
that
Jeez.
if the court did order,
This guy's great.
ultimately, that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video. Because there's no way to communicate to the court efficiently which portions of a video we
It's
think
a
are not
probable
admissible.
cause hearing.
It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it'll probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues, I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court
He is such a
has
helpful
signaled,
defense
which is, I
attorney.
don't want to hear about exhibits until we're in the middle of the
Yeah.
hearing, and I don't want to hear objections about it till we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr.
What I can make to
Robinson's
have for dinner
federal
tonight?
due process rights and the other rights that were addressed.
Well, I might have myself
That
a
litigation does not
cheeseburger,
mean that we should have brought to the
maybe a little
court
ketchup,
proposed
mayonnaise.
redactions to an
I like
exhibit
that.
in a hearing which hasn't started yet, in a hearing in which the state hadn't
Boy,
until
I sure as hell
20
wouldn't
minutes
take this
ago
guy to
even
dinner with
proffered an
me,
exhibit.
but,
So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument.
That's what the judge is thinking right there.
And Ms. Hunt is a very excellent
Yeah.
advocate for her
Boy,
client.
that movie I
But
watched
the
last
reason
night
why the
was really
state is going to
good.
the procedural issue is because the
fantastic.
state, because the exhibit
I'll get a glass
contains
of wine later.
significant content that is
I got
not
a good
admissible,
new bottle
even in a
that I
preliminary.
purchased, you know.
So I'm going to stop now, but I do want to go back and say
Oh,
that
did he
if
say he
the
was gonna
court
stop? Oh.
concluded
Okay, he
that
keeps going
only
again.
Your Honor was going to review this
Well, maybe
exhibit,
tomorrow night for dinner I'll have.
and the Archuleta rule
spaghetti
would be
sauce.
extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
You look like I'm writing
Does that make
something
sense, Your Honor?
down to see if I'm
I
listening.
believe I understand what you're saying, so let
I
me
believe
respond
I
to you
understand.
before I go to Ms. Hunt.
Yeah.
So going to your first point in regards to what this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like, I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant, we could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here.
Sure.
Because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably, for counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits there are no disputes, these exhibits there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going
Thank
to the
you.
last
Phyllis
point,
Watson.
let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes,
He's getting
case
pissed off
law,
at this guy
I
now.
will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job.
Thanks, Leo.
And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to, it's up to the court, about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts.
Thank you,
Ms.
Mr.
Hunt.
Novak, for stopping after you realize you've repeated yourself 75,000 times already.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing, And then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants
He's like
to
the kid asking for a
do
cookie
this
over and over
in
and
what
over
we
again.
would call sidebar or in a closed hearing, that the transcript of that is going to
I
remain
ask a certain
at
way,
least
will I get it
temporarily
this
sealed
time?
until these proceedings conclude,
Mommy,
or the
can
court
I have a
conducts
cookie?
some
No, you cannot.
closer analysis on a
All
on
my
a
friends have cookies. Can I have
topic-by-topic
one?
basis.
No, you may not.
That's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important, so this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, than something like the state has provided, which is we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure, or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Please, for God's sakes.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument at sidebar, because the whole point is to protect my client's right to a fair trial. And by
Exactly.
making
He doesn't need to
part of
ask
this
for any
argument
more.
in open court, I'm
Make your damn
it's
decision.
a self-defeating exercise.
The judge needs to be a
So when the
little bit
court
more strong on
resolves
taking
whether it
control
will
of
hear from
the
us at
courtroom,
sidebar,
in my opinion.
We're prepared to do that.
He seems like a good judge, but
The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that
He's
doesn't
getting
make it
frustrated,
private.
you can
It
tell.
simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
Then we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit of certain portions
God,
of
oh
this
my God,
exhibit
is this guy
beyond
real or what?
Your Honor's eyes. That's what I'm saying.
thanks, At Yum.
Thank you. All right, right now what we're going to go ahead and do and.
Take a break.
What I want to do
Take a
is I want to
damn
look
break.
at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future.
And could you
exhibits. So
turn
that's
the
gonna give
damn
us our
television
15
set,
minutes.
like you
I
told
want to
them to
review
do?
that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting. I just want to bring myself up to speed, so on the next step, when I make my ruling, the court is ready to go.
Okay,
And
fair enough.
maximizing the time, because we also want to put up a monitor, so there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer, just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there. Court is in a brief recess.
Hallelujah, everybody! Hallelujah! Thank you for watching Gray Hughes Investigates, where we cover true crime using logic, reason, and common sense. All right, anyways. Let's take a look at this one. I think you guys have any questions? What do you want me to look up on this, all this new stuff that's out here? If you got here late, this is what is pretty crazy. So in the hearing yesterday, when they showed the surveillance footage, like I said before, they had the same video was flipped. There was something I was going to go look at, though, before we go somewhere else on there. So this is all of the footage I have put together in order. All right, but I want to look at when he goes into so in the early morning, he's in here. See, I think this is the one. Now that's parking level 2 stairs. Okay, so that says parking level 2. And then later on, when it's fixed, okay, and then right after that, so this is parking level 1 stairs. So does it make sense that 2 would be, so that would be the one above, and the stairs should be on the left going down. And this says northeast. Let me go back. Yeah, it's northeast stairs level 2. Yeah, so that's right. This is correct. Wait, is it? Hold on. Let me try it again. God, see, this is where they screwed up by having flipped horizontal video. See, this is correct. This should be... So like, apparently they're saying this is level 1 here. And so that would show them coming up. And then, let's see. The other camera should be 1 stair above here, and it goes down on the left on this other video that was here. Let's see. God, I don't know, man. I think that one might be flipped too. It's crazy. Jesus. It's wild. It's hard to figure out this.
USA.
By quad area.
Sorry, the amphitheater is what I previously referred it to.
Man, I don't know. That doesn't, for some reason, that doesn't make sense again on this one. Because I hope you don't mind me doing this. I just got to try to figure this out. So what is this one? Okay, this one's parking level 1 stairs northeast. Okay, and then when it goes up here, that next flight right there, this is when I fixed it. It says parking level 2 stairs northeast. Okay, that's interesting, right? Because then if that's parking level 2 stairs northeast, then that means that, yeah. So I think that's the same one that's in this one. This needs to be flipped around, in my opinion. Hold on. Let me do this. Here he comes.
He heads out of the parking garage on.
Sounds like Cylon. I used to be able to do that sound. Wah, 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 wah. Maybe you should notice the other battle start.
And actually goes to the quad area of the campus.
That's right. So if you go left, it would go down another flight of stairs.
Makes contact with some representatives from TPUSA.
So look at he actually spoke to people. That's why it took him a while. Well, I don't know which one they're referring to, but he spoke to a couple TPS USA people on this. Isn't that weird?
Sorry, the amputee made.
Okay. Ah, shit. Hold on.
To the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
Sorry about that. I got a phone call there. It's my friend I hadn't heard from in a while. He's 60 years old and he won the U.S. Footbag Championship. And his son was in the finals with him. I mean, it's so crazy that he's still good. He's basically the people, it's like hacky sack, you know. He's one of the people that invented it, really. Like back in the day, I remember in grade school, he'd be playing on breaks all the time. But anyways, what I just did was that is what is the deal, you guys. Look at that other video was also, it's the same camera that was flipped. So that's the correct one. So he takes a right. See, that's really interesting. So I just fixed this. Now this makes sense. All right. Let me show you what's happening here. And this is him heading back to his car. Okay. Now this makes complete sense. Everything makes sense to me now. See, there's been these videos that are backwards. This one was backwards too. And it's interesting because he comes in from the second floor. So what that means is this is what Tyler Robinson did here. Here's the parking garage. He must have came in on the way back on this dry run through this way. Because if you look at it, that one is a floor up. That's on the second floor. So he came down the stairs and went down like this. And then I think he ends up walking over to where his car is. All right. And so I guess let me see if I can get this in here. Plus the camera angles. There we go. See, this is me. I actually went there. And the camera that we're talking about is on the one above this floor. All right. So when you almost exit here, let me see. Let me get into the right position here. Right at the end of the video. See, in that video that we're seeing, let me go back. It's him coming down. Let me see. I get the. So it's the floor above, but the camera we're looking at is. Well, I got to go a little bit further. It's crazy. All right, so right up there. Oops, God dang it. That's kind of blurry. Now, right there's a camera. And so what that's filming is these steps coming down, and then from that perspective, the stairs are on the left going down. So when we go back to this, see that? Stairs are going left, he's coming down. And so I had to flip it to get it correct. So when he goes down the stairs here, like this, he turns right. But he doesn't turn completely right. He then goes and then he veers to the left almost immediately. Watch. See this? Boom. Okay, now it makes complete sense to me. But I'm telling you, those reverse footage is stupid. I mean, because it doesn't make sense if you... But here's the thing. If people aren't really aware, like I bet nobody else on YouTube even noticed that originally because they don't care. When I see it, it's like, okay, that bothers me because I know the area and it doesn't make sense. So you got to get the reality, the truth in there. Okay, so now it makes complete sense. Look at how this works even visually. Watch. There he is. Boom, just like that. And so now we know exactly where that location is. That's outside it's looking out right there. It's this grass right there that you're looking at. See that? That grass right there? That is what he's looking at, right? That camera's filming through there, and he's walking, and his car is parked right behind the wall there. He probably even did that intentionally, so you couldn't see it. But it's parked right there against that wall. Isn't that amazing? Oh, man. Holy crap. I love figuring shit like that out. But see how, like, that's the solid wall there? And then look where he walks to. He pulls about right in the middle of it, and then he gets into the car, and then he pulls out and he exits. All right, so it all makes sense to me now. I was confused yesterday because there's 3 different times they used footage that it was backwards, horizontally incorrect. See, now it makes all the sense in the world. Just like that. All right, very cool. Yeah, the details really do matter. And if there was ever a person, I mean, the thing is, somebody on a jury isn't even going to know the layout really, and I do because I've been there. And like this here is really, you know, basically what you're seeing him do right here on the video is he came down from here, and the reason he came down from there is he went in that other entrance when he came back because it's a floor above. So he walked down the steps here. And the camera that's right there filmed him come down these steps, then down these steps. And then what we see him do is sort of veer off to the right and then go down there. I'm not sure how to how to film this. I think I got to keep moving or something. Hold on a second. I was putting away the camera. So he went right through that section right there after coming down those stairs. So from right over there, he came down. Then he went right through there, walked to his car, and then he drove it out. And then I think, I'm not sure if you can get out on this floor, actually. I'm not sure. Let me go look. So if he's on that floor, he's up one. No, he had to drive around and come out. See, that's a floor below. See that? That's right there. And then the one we're seeing him on right now is this one. But if you go over here, he had to go down a floor because he went into this one. See, this is all stuff that you can figure out using logic, reason, and common sense, and you won't see another channel even have any idea what the hell they're looking at. So right here you have him going in, and that's a floor up. See how the top of this, I'll just keep going across. That's up here on this floor. So he had to go down the stairs and come out there to get to his car that was parked on this level. However, that level, if you continue it around, is up here, right there. So that means the floor that he came in with his vehicle is a floor below. I mean, that's weird. Let's go look at that when the car comes in. So that's where the original entrance is. Okay, there you go. So he comes in and he takes a right and so forth. And this is when, so he does park right here. So it's interesting. I'm not sure what camera this is, if they're using the same one, because you can still see. Like that camera there is the one that they use. So they must have one that's out in the main area. And I should be able to see it even in here. Let's see. Let me go back a little bit. There must be a camera that's just like right up above, maybe that thing. I don't know. Let me move a little bit. Man, I'm twirling it all over the place. I think I saw it one time when I was looking at this. And I bet it's right up here. I don't think I went. Oh, let's see. Oh, there it is. I think that's the camera right there. I think it's filming that direction. Isn't that crazy? I think that's what... Look at that face. Ooh, Jesus. But anyways, I think that's it. Right there. That might be the camera. And I don't think they're back in court yet. No. Anyways, do you guys find that interesting at all? Seems like hardly anybody comments. Like it's just yeah. Let's see. It'd be great if people actually commented on what I was talking about. That'd be awesome. So this is okay. So this one is at in the morning time, and notice how he does the same. So this is right before that. He comes down the stairs. So yeah, that's interesting. He came in on that further entrance. So he was on the second floor, and then he walks down. Now he's on the first floor, but you park on, I think, probably a basement level. And now he walks down there, gets in his car, and then right there out there, that grass is actually the grass that's outside that we see. I guess you guys are spoiled. It's like, it's, I don't know. Just hoping to God there's people that actually see the difference here. Like, we actually know what the hell's going on. It's different. And then here, the car is leaving. And so this must be when it gets, I mean, that does look like the entrance point. So that's the first floor. So it's kind of interesting because I think, I don't know, it's hard to make it out, but I would think you could exit over there. No, this would be the basement. I think it's saying you can park on at that level there. And then here he is later coming back. This is the dry run, okay? And he's wearing the same maroon shirt that he has at the police station. And there he goes walking by the house that I found out was actually 10:07, not 8:07 like Candace Owens tried to tell people. And then here he is walking into the tunnel at 10:09 and some odd seconds, which makes absolute sense. And then he goes down into here and then up the stairs like this. And then there's that camera showing him exit the building. And when you see him exit the building, that is right here, right in that spot. And then when he goes onto campus, apparently he goes over to Chick-fil-A. And then he goes over to, so Chick-fil-A is in this building right here. As a matter of fact, there's a Chick-fil-A. It's in this building here. And then after that, he apparently went over to the wooded area and left his backpack. Then he shows up again in this building and then crosses over this bridge here and then walks over here to the edge of this railing. And he stands there and he looks. And then apparently he left campus again. And then I think then he practiced how to go get an item that he leaves in the wooded area that he already had planned. So he goes up to the street up here, and maybe that's when that construction person was like, hey, you can't be here, because that's exactly where this is. And so he went, he probably went down, and he could still figure out how to do it. This is the house that has construction. This house here is the fence line that the gun was on, near. So he would have to go down like this. But I think when he went up, later he confronted somebody regarding construction. We don't know the precise time of that. But I bet you he went up here and saw, wow, I can just go right down the edge there and go get my backpack, which would be representing the gun later. So now he knows if he just parks right over here later, he can, try to go get that gun because he knows how to do it. But man, there's cops down there and he was never able to do it. Isn't that crazy? I think that's exactly why he put that backpack there as a test of recovering it again from the other side, which he knew he was going to be doing. He wasn't going to be walking around down here. What do you think of that? Huh? What do you think of that? Amazing, huh? And then there's some just crazy stuff. So if you haven't read the documents or anything like that, right at the timing of everything is so perfect. It's just almost unbelievable. So after the shooting, he jumps off the roof over here at 12:24. He's on the ground. Then he goes across over into here, and then he has to take off his shirt, etc. And then he exits the area. And so that would be like 9:25-ish into there. Then he ends up running back over here at 12:29-ish, maybe 12:30. And then it takes about 6 minutes or so to get from there to where I believe his car was parked right there, which actually is a picture of it. Parked there. We went over that earlier. And then from there, so that would probably be about, 12:36 or 7 or so. And then from there, he drives all the way over to this mall, and he parks there at 12:44, at which time he does a search to go to a car wash, which is, he ends up picking the Quick Quack car wash, which you pull out. So from that parking spot, you'd pull forward, and then maybe go to there, or actually you probably have to come out over here because there's an island over there. So he probably pulled forward from this spot and then had to turn up into there, and then he drove down all the way to the Quick Quack car wash right there where he was there at 12:57. And then we see, we have a video of him showing up on campus again at like 6:30 something, 6:36 if I remember correctly, and it's at night. And in that video, he pulls up to right here, this intersection, and he looks like he's going to turn, but he notices there are cops, so he goes forward. And I think that's when he headed out to Dairy Queen. And he had something to eat. He's just watching and watching and watching. And then later in the evening, he shows up, and his car is parked right here across the street from this house. And you can see that he actually exits the car and heads that direction. There's only one of two directions he could have headed. But you know what direction he headed? Exactly the direction you would head to try to get that rifle that he put in the woods there. Okay? Exactly in that spot. And he wasn't able to get it. He actually types it in and says, they're still lingering. I'm not going to get that. And that really sucks. And then he drove. Oh, and by the way, before he drove home, while sitting right here, he does a search. And it says, all right, remember that part I said, all right, I'm going to have to leave it. And that really sucks. And then he does a search on his phone while he's sitting right there to say, hey, how do I get back home from this location? He types it in at 1:33, and then at 1:35, he drove away. I mean, it is, I wish I could present this shit. I think this is like, it's so obvious. It's crazy. It's crazy. Hey, look at that. We got a Wild Bill Wassman wave going on. Please help support that wave. I would really, could use your guys' support when I do these shows. I don't get the 15,000 people watching, people that don't actually know what they're doing when they're covering it. I get 200. So if you could help support this channel, this is great. Or that would be great. All right? I mean, if everybody did 2, we would do well. Unfortunately, I have to rely on people to do more than 2 to make the goals because very few people join in on the 2s. They don't even, most people don't support the channel regardless. So it's like I need, multiple people to do it. It'd be great though, wouldn't it? Hey, thank you, Tracy Von Bratt. Very cool. But how was that right there? I think what I just said is a reality. And now if you missed it earlier, the video, the aerial footage, I think it's absolutely incredible how the vehicle is the vehicle. I mean, like the Dodge Challenger that you see on the aerial footage taken at 11:28 and 11:16, but it wasn't there at like 11, is his vehicle pulling up to this spot to do his final run. I guarantee you that is a reality. Because look where it is. It's on the exact street where he just comes this way, turns right, and then goes by that sawtooth fence that's over there. And it's right on the same street that you see him earlier walking by when he does his dry run. So there you go, man. It's going to be the reality. Hey, thank you, Stevie Lynn and Timothy Cecil. Hey, keep the wave going, you guys. Let's see if we can get this, get anywhere near the goal. We're at like 50% right now. Maybe 51, 54 maybe. Hey, thank you, Joey. Appreciate it. And there's so much more to break down. I could sit there and do the whole damn thing that fast. Originally there's a guy that said he thought that he parked right there. And it's interesting because in the very first day, when they mentioned the map, they specifically mentioned West 850 South. I thought maybe he parked right there. I'd been there. This is a great spot to park. I mean, he moved his car around too. It wasn't just sitting around. But look at this, right next to that fence. Then there's a fence on this side. Then all there is that house. But all you have to do is have the car facing that direction, which you would be on that side of the street. Open up your passenger door, change your clothing right outside your vehicle, and nobody would see a damn thing. Look at that. Who would be seeing that? All you'd see is a car come around, and then you look like you're doing something else. So there's that one. Then the other person who had the idea was right over here. I'm not taking credit for it because I didn't come up with this spot. And that's what people should do on YouTube. They don't. They steal other people's work and claim it as their own. And everybody, oh, wow, great thoughts, man, great thoughts. And they didn't do that. So here's a fence, and there's a fence there, and he could have parked right there easily. Would have worked also. And that's on that street that they mentioned. So I think, however, if he did park on that street earlier, he's more likely at this end here because he starts his dry run going this direction around. And it could have been just that he wants to take another look at this spot again, you know, because he knows that he's going to be putting the gun down there. And, I mean, the planning on this thing is crazy. He's just an idiot. I mean, he planned the hell out of it, right? But the other than that, it's just stupid. I mean, how many times was he on camera walking around? The guy just clueless. He thought, oh, well, if I just change my pants, I'll look exactly the same with my hat and my glasses, but don't worry about that. And by the way, after showing this right now, is there anybody out there that believed in Candace Owens crap, but now that you see the reality, you're like, wow, she doesn't know what the hell she's talking. She doesn't. Here's the truth, everybody. Candace Owens does not know this case. She doesn't know the facts of it. She knows nothing. She just spends every day with, like, if there's some weird anomaly, like, oh, hey, this guy was on an airplane flying from, oh, my God, and then turns it into a whole show about something. And I think it's scary that people believe that stuff. You know? I mean, it really, there's something kind of scary about it. So he's taking his time here to make sure he's reviewing this. Now they're probably having debate in his office and chamber. You know how this is going in there. This shit might not even come back out till 3 o'clock because that idiot, other attorneys back there, probably just going, well, how about the fact that, you know, what about the, you know, he's just, you know, he's back there. Because here's what he knows. He knows that the stuff that Tyler Robinson's boyfriend, or, you know, however you want to refer to the person, the furry boyfriend, that person, the stuff that he says on the video is so incredibly damning that he just doesn't want that out there because he likes the Candace Owens of the world. He likes the stupid-ass Baron Coleman. They love those people because they're putting out garbage to hundreds of thousands of people, millions really, and they believe it. So once you start putting out the truth, some of those people get peeled away. And that's why they threw the homage in there yesterday when the defense attorneys had to say stuff like, oh yeah, hey, what about that bullet on the roof? Hey, what about there was about 5 different things that they brought up that were directly from, oh yeah, the paving over of the ground. Really? Well, you know, you're just trying to throw an homage out there to the Candace Owens nut jobs. I'm surprised they haven't brought up the airplane. You know, hey, what about the airplane that took off? Did you know about that, sir? The Egyptian plane? Did you hear that, guys? The attorney actually brought up the plane. Hey, yay! You guys are sick, you know? And I'm going to tell you, anybody that believes in Candace Owens, you need a lobotomy. She is a lying... I mean, okay, you either have to believe this. Candace Owens is a really stupid person that can speak really well, or is intentionally manipulating everybody for the views and the millions of dollars she's made on the death of Charlie Kirk. Okay? I think the second is the truth. I think it's hard to be really stupid and be able to talk the way she does. So the truth is she is intentionally tricking the public for, you know, to make the millions of dollars that she's making. I don't care if people make money on YouTube. Here's the thing. I have a problem with people that put out fake information that make money on YouTube in the true crime genre. You know why? Because I'm like a unicorn in the true crime community. Literally. I'm one of the only people that literally just sits there, puts the facts together, and then it all makes sense. But people don't want to hear it. Isn't that sad, you guys? People love the conspiracy angle, digging into just garbage all day long. It's crazy. They get thousands of viewers when they do this stuff. And I'm even talking about the ones that you guys like to watch, you know. They always give a little angle of doubt somewhere. Ooh, look at that. And that gets you to want to go watch them. I don't do it, man. I can't do it. I'd be embarrassed. I'm just going to tell you what the truth is. And it doesn't stick though. You know, you get like 200 people watching, 240, okay, I gotta go. Hey, where's that other one? I gotta go watch that other. It's stupid. And then there's other people, like you can make money off of discussing the Candace Owens stuff all the time. And all I want to do is just put the case together, put the facts of the case together. Every case that we do, I try to find documents, etc. And, you know, some of this stuff, though, it's so awesome to get this new information because it just fills all the stuff in that we've already said as reality. So when I would say all the freaks in here, even Wild Bill Wassman, you know, when the legendary bass fisherman, when we see all this surveillance footage, it's like it's not even new, really. I mean, we're seeing it new, but the information in it is just confirming all the stuff that we've said is incredibly likely to be on camera, including the 360-degree video of the rooftop. I made a video about a month ago that shows exactly what's on the same video that they released. How he walked on the sidewalk, around, went into the Losi Center building, then he comes up onto the roof, and then he runs. I have the exact spot that he's running from, goes over to the edge of the roof, etc., etc., etc. You know, it's crazy. And so I guess maybe if you don't want to not have a surprise when the trial happens, maybe I'm not the place to go, you know. But if you really want to be up on what the reality is prior, then this is where you want to be. You know what I'm saying? You know what I'm talking about. And thank you up there to Honey Bee Fly. We also had Jessica Schubach, Timothy Cecil, Stevie Lynn, Tracy Von Brott, Lisa Valenzuela, Phyllis Watson, Wisconsin Cat Mom, Allie Cake, Kim P., and Wild Bill Wassman, the legendary bass fisherman. No joke. Now, so that was almost a 6-pounder the other day, right? 5.9. That's pretty big. Not 5 and 9 ounces, right? You're talking about 5 and, you know, like right near 6. Oh yeah, you don't want to. If you want your IQ to suddenly drop, go watch Candace Owens. She caters to the lowest common denominator in society. The 50% that are just dumb as a box of rocks, you know, and those are the ones that go watch that. That's not cool, Gray. She just has a different opinion. Absolutely bullshit. She knows exactly what she's doing. She is a liar, and that's the truth. Hey, thanks, Honey Bee Fly. Very cool. I'll be listening, freaks. Yeah, it'd be cool if you guys could help support the channel. We're still, you know, we're just kind of like at about 60%. You know, we've already been on there for almost 3 hours. It'd be nice to do a show where at night I don't feel like I have to go do another show. Yesterday I did 10 hours of streaming, and it was just sort of a average, just a little bit above average day, you know. That's a lot of work. See, let me show you what the deal is with where that car is parked. His Dodge Challenger. Look. So let me go all the way to the beginning of this clip. So you can see him over there, and the time on this is 11:45. Remember how we said that vehicle was parked at 11:28, and it's parked right here. It's actually there at 11:28. I would say moments after, like not moments, but like let's say 10 minutes after this is when he actually had got out of his car and started walking this direction. With that limp, it's going to take a while. And he just came down to this intersection here, and then he crossed the street, turned, and he goes this way, just like that. And then right here, which is crazy on Google Earth, the same two cars. That car, I think, might be the same one. I don't know. But this is where he's filmed walking in that video we just saw. So all he did was go from right there down this way, and then he turns onto this street, and then we see him on a camera at this house, and we see him a camera at this house. It actually looks more like this. When he's walking by, then after this bush, he turns right, goes over the bridge, goes down here, goes through the parking lot, goes into the tunnel, and then he goes through the tunnel, takes a right, and then goes up a set of stairs and comes out right here, filmed on the camera that's right up on, actually right up here. It's like right there filming down, and it shows him turn left coming out there, and this is on his final run, and then I think he went up down here, went up the shortest, easiest way to walk with that leg, and so he wanted to minimize the number of steps, so he went up just like how I have it, like this, and then up and around and up over here, and then we see him on surveillance footage come around right through here, walk right along the sidewalk, turn, go into the Losi Center building at 12:03-ish or so. He shows up on camera at 12:02, but maybe 12:03 or 4 based on his speed. He goes into here, and then I think, they don't have this on film, but I think he came out this door here, and he went right over to this spot right there. And he could see the stage area and listen. And I mean, look at the spot right there. It's crazy, but watch this. Right at the tent. You can see it right through there. So I think he sort of waited out here until he could tell that Charlie Kirk was on stage answering questions. Then after that, that would probably be at like 12:13 or so, and then he turns around, and then he goes up these stairs at 12:15, after turning around and walking from over there, and then he stands over here at 12:17. He's standing, looks like about right here in that video. Then he hops over. That's when he takes the rifle out of his pants, puts it together with a screwdriver, and then at 12:22, he stands up and starts running across the roof. He goes right over to this corner over here, and he fires at 12:23:28. It's like right when it's about to turn 29. It's like right in the middle of 28 and 29. 12:23:28. He fires. Then he gets up and he runs across. We see him right there at 12:23:34 running, and then he runs right over here to the corner. And that's when he sort of lets himself down. He puts his foot on this ledge right here and then jumps. It's about a 10-foot drop. His feet are about the height of a basketball hoop. And then he lands on the ground, apparently leaving a footprint. He left handprints up on the ledge there. I have those filmed. And then he went running across over here, across into the wooded area, where he then left the blanket and the towel, which he had already had planned to leave there because he already tested it out with the backpack. And then he leaves it in there, and he changes his shirt, etc., puts that in the backpack, and then he leaves. Now, I don't know exactly how he got out of here, but I do know that he eventually makes it to over here. So there is a way you can go up this bank here and go across. But he ends up running back here, and then he goes over there. You see him on that video come running back around here, and then he goes out. So because you already know where his car is parked, then he must have gone up this way, and I would imagine he's again filmed on that same camera. So he's going up here, and then he makes his way to the vehicle, and he probably gets to the vehicle at something around like 12, 12:39, I would say. And then once he gets to the vehicle at 12:39, he drives over to this parking mall, and he gets there at 12:44 and 50 seconds. And then at 12:46, while he's still sitting there, he does a search for a car wash. And then that's when you see his car pull away. And then he actually heads up to the car wash, and they have him up there at 12:57. Now, I don't know, that seems a little like, that's a couple minutes longer than you'd think that it would take to get there. But, there's a lot of lights also. I mean, if you think about it, you're right here. You've got this light to wait at, and you drive down here. You probably have another one, I don't know, like this intersection again. And then, let's see. Yeah, we're not even at the car wash yet. Then you get to this intersection, another light with a lot of cars. So it could have just taken that long to get to the Quick Quack car wash. And so we could actually go down here and take a look. We'll see. We're going to probably see this at the trial or something. That there's a. Is it right over here? Is this different? What is this street view here? It's 12:23. Let's see. But anyways, how was that, you guys? Didn't that make sense? The whole thing. Oh, I think is that it right there? No. Hold on. Let me type that in. Quick Quack. Yeah, it's right there. See? Oh, I guess, is that it? Let's see. That looks like a... Doesn't seem like a car wash. Oh, it is, yeah. So that's where you're going to see him, right there. Quick Quack car wash. So apparently he's right there. Now maybe you can pull up in some of these stalls and clean too. Man, what a delay this has been. 34 minutes extra already. That's ridiculous. That means there's arguments being made, and the judge is sort of, yeah, I can see that being okay. Oh, jeez. He needs to just put his foot down sometimes. It's a preliminary hearing, for God's sakes. I guess he's kind of nervous, you can't unring a bell, like it's already happened. So you don't want to ring the bell in the first place. Or you want to ring the bell the right way. I guess it might be the term. Yeah, and that was the final run that I just went through. I think I pretty much have everything memorized now. We know that on his first one that he came in the morning at 8:28 when you see the video of his car being pulling in there. That's when he went out on campus and he went and looked at the wooded area. That's all he did. That way. So he went to the wooded area twice, on 1 and 2. Oh, actually, he went into the wooded area on 3 in a row. He went to the wooded area. He went on his first one. He went there on the second one. That's where he left the backpack there. Then he goes back there again on the third one, on the final one, when he went in there to change clothes and leave the gun and the towel in there. I mean, you could make the argument, but it doesn't seem like it. It seems like he intended to leave it there. That's why he'd been there a couple times. It seemed like he wanted to figure out a way to retrieve it. That's why he left his backpack there. So, we could argue that he didn't have the screwdriver to to take it apart to put it back in his pants, but that might have just been a coincidence. Like that's why he didn't do that, because it seems like he intended to leave it there and go get it. Yeah. So on the first time he got there, he went over to the wooded area over here, and then apparently he went down to down here where the shooting took place. And then he went back to his car. It was in the parking garage. I was thinking about it. I might go back out there. Yeah, I've talked about it. I don't know if when he goes there, I might go there, but I might just go when I go there. I've already gone there. Yeah, it would be cool to meet up again. Maybe I'll see when he's going. I got a lot of stuff to. I wish they would show more surveillance footage though, so I could go film the exact thing. You know. All right. Well, let's see. Well, I got to use the restroom, so I'm gonna go ahead and. Go and I'll play some of that. I don't know. Maybe I won't play the music in case it comes back on. You know, if it comes on live, it'll have an audio. Hey, thanks so much there, Doreen Bowler and Honey Bee Fly. Doreen said, appreciate your good commentary, sound analysis, and outstanding documentation of this case. Well, thank you. Thank you, Gray, for keeping all of us entertained during Tyler's defense team nonsense. Yeah, it's like, it's stupid. You know, I know everybody, sometimes they're like, I want to hear what he has to say. I mean, but come on, he's just dribbling nonsense, you know, and it's stuff that we're not going to know, you know, like this, all the little ins and outs of 1102 or whatever the hell they're talking about. I know you want to think whatever you want to think. I don't agree with you. I just explained why. It's pretty clear. Yeah, I've already explained it to you. No, do not comply. I don't agree with you. I know you're just trying to be opposite based on the name that you're using as a your name, but it doesn't make sense. He left his backpack there so that he could go retrieve it from up above later. Okay, so then he even says in his notes that his drop point, he actually has it planned out that he's going to do that and then go pick it up later. It wouldn't be incredibly shocking if the other scenario is correct, but none of the circumstantial information indicates that. So I don't agree with you. Okay, now if it turns out that he did do that, that he meant to take it apart, it wouldn't be shocking to me because I've said the same thing, but I don't agree with you now.
Court is back in session.
All right, here we go. Wow.
Noting the presence of counsel and all parties, I appreciate your patience. Sometimes it takes time to save time, and so that was the intent of this court in addressing what is before this court as it relates to State's Exhibit 16. Counsel, in this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail. All right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees, it is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again, to be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript, as it relates to State Exhibit 16, may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video, so both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering not to be published? I've got 3255 to 3548.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
And that's from 3255 to 3548.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Here he comes. Here comes the lunatic. Look at the judge.
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because I do think a closed hearing is appropriate.
Here comes the lunatic.
There are, okay, setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay? Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay? I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the due process clause of the 14th Amendment, even without a showing of prejudice.
Which one do you like better, that one?
Demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them.
I like this one too.
And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right
The
not
rodeo
to have what
clown.
the state calls a confession
Hey, thanks, Wild Bill.
televised. This court has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology.
I like the
but I'm
first
just
one,
going to
too.
use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights.
That's right, he is conducting
Right here and
this.
now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it because the court's decision to allow this video to be televised and the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
So, and I appreciate that clarity, and perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that
see, now he's getting weak again. He's caving in.
3548, which is being excluded, or is it in the
It is
court?
not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to
making
do
him
it in a
nervous
closed
with his
proceeding because nobody
Supreme
has to be
Court
obtuse.
crap.
I don't have to be
Oh,
obtuse
God, he's
in
going
order
to cave
protect my
in.
client's
He's going to
rights.
cave
No, I
in.
appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread,
There you go.
and
Nice.
I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago.
That might be
in
more
their
than-
entirety.
Judge, if I may, they were not released in their entirety.
Right, that's what I
Portions
thought.
of them were placed into the charging document, the information that supported, in part, the charges that the state has filed.
Right.
We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells. I want to make sure.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred
It's
to as
just audio.
confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party. We have not filed anything in this case that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into evidence, and the court knows what this note is because if the court's now watched the video, that's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right. I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything audio and visually displayed, but the state's position is we just want the audio played.
Right, but what's it? So I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
All right, so help me understand, what's the difference if the audio's played or the videos played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. And I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twiggs' video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then in the future move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with audio, but hearing the tone, the context, all of that, that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience, is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations, because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now, I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
Sure.
Um, 'Cause, 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 citation to state standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right, thank you. I appreciate both parties advocating and arguing. It's helpful for the court.
He doesn't want to ring a bell that he can't unring. That's what he's thinking in his head. If I let them read this, will this cause undue prejudice? Oh, but isn't, like, facts always, prejudice? Like his DNA is on the gun. Well, don't let him know because it's too prejudiced. Well, I know, but it's real. See, he's kind of, I think he's like right on the tip of not allowing this to be heard. I think he might be checking it one more time over and he's going to go, okay, yeah, I don't know, that seems pretty.
All right, so in taking in consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8,
Wow, this sucks. I mean, that had really damning
and
stuff
sorry,
in
I'm
there.
just trying to,
So he's going to allow it, but he's going to take more stuff out, meaning it's more stuff that really implies that Tyler Robinson did it.
sorry, starting on page 7, right after 8, is that at 8?
He shouldn't have to do any of this crap that he's doing right here. I mean, this is like
Well,
nowhere near the level
let's
he should be
start.
worrying
Starting on
about.
page 6.
Page 6 now. Jesus.
Now, let me go back here.
He's getting rid of all the stuff that's meaningful at this point. But hey, guys, if you're out there and you want to help support the Gray Hughes
Starting on
Investigates
page
YouTube
6,
channel, could use some
after
channel
6
memberships,
minutes and 56
super chats,
seconds.
etc. Page 6. Now, hope he stops like kind of quick. But yes, could use your guys' support. Thank you. He's getting rid of more than just those 3 minutes. And that's a lot of stuff, too. Man, you look how many pages he's flipping through. Okay, we'll let you do page 1 and 36.
Going to 20 minutes and 27 seconds. For reasons such as 403, under Rule 403.
How come you didn't decide that earlier?
Again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
Restate those times again, Your Honor.
6:56 until
20 something.
right, the line before 2027. Or 2027, just so, until 2027. Is that,
He just wiped out about
and then
half.
and then what the court indicated previously from,
They should make the text available
3255
quick.
until 3548.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 3255 to 3548 and 656 to 2027, those are just not being published, but they have been admitted for Your Honor's consideration.
Right, so kind of going through my three-step process.
They are published.
Exhibit 16
It's
is
published.
an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this
Yeah,
case.
but
So
for publicity,
what I'm talking
public.
about here is this is only what will be published in the courtroom and on
Audio.
and captured by the video. Is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to
That was kinda
redact
obvious, and I
anything
know
in
she
here.
didn't know that.
It's going to make its own determinations regards to relevance, and everything that Mr. Everything
Novak.
that Mr. Novak noted, I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
Hopefully you can get them to change something. These guys are, the other guy's really good that was there yesterday.
Your Honor, I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I do want to reiterate the belief that providing access to the documents on which the court bases its proceeding,
what's wrong with
bases its
publishing the
decision in this
truth?
proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there. Something else is being kept from them that isn't. And so not only does it run counter to the idea that, of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And, all right. Counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand.
Oh, man, this
the
might
state,
make a
the
difference.
defense, and the judge, you're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to.
Yeah, and voir dire.
That's it,
And
Your
jury
Honor.
selection.
To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final
I don't think that
ruling
changed his
to
mind.
clarify what's been stated, just so it's clear to all parties? Mr. Novak?
Oh, God, Novak.
Your
again.
mic's
God
muted.
damn it, Novak. Just get the hell out of here.
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media
That's the
counsel's
reality.
suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect
I hope he changes his mind
Mr.
because of this
Robinson's
guy.
right to a fair trial.
I think he was going to stick
All
with
due
this guy.
respect to
I think he was
the
going to
Kirk
stick with
family, with all
Novak.
due respect to the media, and with all due respect
he
to
might
the
be changing
public,
his mind now.
the number one
So I was
concern
looking
in
at
this
something.
proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions
I
being
was
put
thinking he
out
was
to the
reading
public.
it.
Could you cite to Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. and we all understand how complicated it is to figure out what
This
comes out
idiot,
of
by
a
going back up
Supreme
again,
Court opinion
gave
when
him time
there
to look it
are
up.
multiple concurring and dissenting
That's
opinions.
hilarious.
But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do, we could go down the rabbit hole.
I wonder if this
what are
attorney
all the different opinions
specializes in
Rideau and
constitutional issues.
why is Estes citing to a dissenting justice? But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, and then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you.
See, Tyler
I
Robinson
appreciate that guidance,
was
Mr.
given
Novak. So,
a high-end
taking into consideration all the factors,
group of attorneys.
the previous edits, starting at
literally top-of-the-line attorneys. I mean, we don't like them, but
I believe I said
that's who he was
starting
given.
at 6 minutes and 56 seconds, going to
He's going to get rid of all that.
20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 3255 until 3548. Does that comport with what I previously said?
Yes.
All right. And then from 3548 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erika Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence, and based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act but I'm trying to act in the interest of justice in making this balancing act and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, none.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
That's what we prepared for tomorrow. Oh, I see what you were saying.
And I know the state's engaged,
Raider.
but if someone
I thought you
could
were
send a
saying I was
copy of
drinking.
that to the court after it's been reviewed by counsel, so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way, we can save time as well.
Now, how would that make people support
Thank
the
you.
channel, Raider, by people drinking? I don't understand. But I do need the support from the people watching. That's the only way we make it here. There's no ad revenue. There's nothing other than you guys. So if you like it, then if you like what I do here, I think I put out a better product than everybody else. So if you have the ability, that would be great. I wish I had more viewers, but it is what it is.
Judge, it's the state's position that we close for today, come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis. As to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just
These guys just keep putting more on,
making the court aware
more
of
on,
that. It's
getting
a
rid of
much
stuff.
simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the SD's issue. And I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements that the
prosecution will call confessions. So maybe that's something.
It was a different prong that I was addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made
For
public.
evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank
No
you, Mr. Novak. And if you would mind, obviously, sending a copy to the state as well.
Oh, of
so
course,
it's not
of course.
ex parte. All right.
So, is the court referring to a formal filing?
No, just if you
A bench
want
memo.
a bench memo, and that all sides can have a take a look at, just to prepare. Again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So
happy to do so.
If you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right. All right. Is there anything else for this afternoon?
Not from the state.
All right. To defense.
No, thank you very much for your time, Your Honor.
All right. Court will be in recess until 9 o'clock tomorrow morning.
All right. Ah, jeez, what a joke. Yeah. I think this judge is starting to be, he's caving in to these, sort of slimy defense attorney, the Baron Coleman type people of the world, they're just sort of absolute morons, just trying to, they word salad you to death that you go, oh man, I must be doing something wrong. He needs to take over and be a little tougher, I would just interrupt him sometimes, go, listen, you said enough. I get it. Okay? But he doesn't want to appear to be, you can see it on his face that that's how he actually feels. But he doesn't want to sound that way because then it's like, oh, you're being prejudiced against the defense team. But I guess that's it for for today. So I'll try one last time in here. If you guys want to help support the channel, if you like all the stuff that I've been putting together, I would appreciate it. Maybe buy some channel memberships for people. There's a lot of people that can't afford it. If you guys could buy some of them, channel memberships, super chats, etc. My channel, unlike others, we donate also out of the income from the channel, thousands of dollars every single month. At least we try to. We've given $300,000+ We just reached the $300,000 mark this last month, at the end of the month. And that only happens when you guys are supporting the channel. And here we are again on another show, and it's just really, really difficult with, even if you have just 200 people watching, it should be simple to reach. But it doesn't seem like it's the case. We didn't even make 60%. So if you have the ability to, I would appreciate it. It seems like when I'm saying this, it just goes in one ear and out the other, but it's really important. All right. So if you have the ability, that would be great. I don't even know what today's hearing, what was in it. And I'm trying to, how did it start off, What was the original I don't even know, man. It just seemed like it never moved anywhere. It just sort of stayed in the same place. Was there anything today that was even... But did anybody hear what I just said a minute ago? This just seems so... I don't know. It makes me feel like it's... No, it's not a good feeling when you're asking for the support and none shows up. This is all we have here, you guys. There is no ad revenue. They always demonetize my video, live streams, and that means every single bit of ads that may have played, they go to them, but we don't get shit when it's demonetized. So it just is what it is, you know? Yeah, that's what I feel like. I feel deflated and let down. Yeah, exactly. Yeah, I don't remember anything that happened during the day that was even, like, was there anything that was interesting? The most interesting part was me going back over the surveillance footage and determining what actually they were saying. I almost thought that was part of the trial today. Well, I guess tomorrow's another day. Tomorrow starts early in the morning, though. So we'll be back again, hour after hour. Yeah. Oh, yeah, that he came in with the same clothing. That was it. I put that on Twitter, that image. But anyways, thanks for watching, everybody. Really appreciate it. Thanks for those who did support the channel. We had Carrie Lou, and then Laura 42, Susie Q, Born to Raise Hogs, Carrie Lou again, Stacy Von Brott, Phyllis Watson, Carrie Lou, Wild Bill Wassman, Tracy Von Brott. These are like, let's see, 1251 was that one. This one was at 125. Huge gap at there. 126, 127. By Phyllis Watson and Tracy Von Brott and Alley Cake again. Then we had Yum at 138. Wild Bill Wassman at 141. Wild Bill Wassman at 211 because not a soul donated during that time frame. Then we had Kim P, Alley Cake. This is all during this like little flurry of these $2 ones. Wisconsin Cat Mom, Phyllis Watson, Lisa Valenzuela, Tracy Von Brott again, and then Stevie Lynn, and then Timothy Cecil, Jessica Schubach, Honeybee Fly, and then Honeybee Fly again, then Doreen Bowler, that was at 237, Honeybee Fly at 237, Wild Bill Wassman at 249, Tracy Von, and then from 249 all the way up until 319, none, and then we had a 99 center, and then a 499 from Tracy Von Brott, and now it's 335 and no more. So it's just sort of like just died down for no apparent reason at all. Nobody knows. It's hard to make the goals like that. You would think that because I'm covering it factually and doing it, I think covering it better than anybody else, that we would easily make the goals during the show, but we don't. But if you're watching one of those conspiracy channels, boy, it looks like a freaking slot machine in there. Unbelievable. I guess they know what they're doing. I don't. All right, thanks everybody. I'll see you tomorrow. Be safe out there.